Welcome to the October 2025 edition of Outline. We're back after a slightly extended summer break. Apologies for the unavoidable cancellation of last month's session, which we shall be rerunning, or will be running shortly. But we are back after a long summer break, and with the heady topic of biodiversity net gain that we'll be talking about today. As usual, we will aim to keep the session to about 45 minutes to an hour, certainly no longer than an hour. And we will be just discussing the topic. We'll have a Q&A session at the end, so if you do have questions, please do use the Q&A function to ask those. But also with this, we're interested in how BNG is working on the ground, and I'm conscious that a number of you in the audience will have different experiences and different perspectives. So if you've got insights you want to share, please do drop those in the Q&A as well, and we'll try to sort of work those in as helpful practical tips for others. So please do participate. But my name is Trevor Ivory. I'm a partner in the planning team here at DLA Piper. I'm joined today by a senior associate from the team, Henry Jeffries. Henry being our guru on all things BNG, so we have a proper expert. I think between us we've advised developers, we've advised landowners trying to provide BNG on their land, we've advised central government, we've advised those looking to set up systems to sell biodiversity credits. So we've got a bit of experience between us, and particularly you, Henry. So welcome. And it was, I think, we were just saying before we started, December 23.
That's right.
We last had an outline session on BNG, at which point it was all about to come in early in 2024, wasn't it? So we were looking at what might be, whereas now, today we're going to look at how it's actually been working in practice in the context of the Town and Country Planning Act, and also have a look at where we are with NSIPs, nationally significant infrastructure projects, and the rollout or potential rollout of BNG to NSIPs as well. So welcome, good to have you on board, Henry.
Yeah, thanks, Trevor. Good to be here. And I mean, as you say, December 2023, we were looking ahead to February 2024, which was when the statutory requirement came in for most TCPA developments, and then April 2024, which is when it came in for small sites. So it was very much a look ahead at that point, whereas now we've got the benefit of hindsight. We can go back and test what we said was going to happen, and also we can do another look ahead to the NSIP regime, which at the moment is looking like May 2026. So I suppose I imagine most people on the call will be relatively familiar with BNG by now, but I can run through at a very sort of high pace the underlying requirement, and then we can get into some lessons learned, which is probably the real interest. So, I mean, in terms of as a concept, BNG isn't anything new, I don't think. It's been in the NPPF for some time as a policy requirement. What was new in February 2024 was the statutory requirement for BNG, which was introduced by the Environment Act into the 1990 Act. And the way it operates is through the introduction of a deemed condition. So the deemed condition is automatically applied to new planning permissions, which fall within the bracket for statutory BNG. And what that condition essentially says is, prior to commencement, you have to submit to the local planning authority a biodiversity gain plan and have that plan approved. And what that plan has to do is set out how you're going to achieve 10% biodiversity net gain, which is measured as against the initial biodiversity value of the site. So it's an uplift of 10% on that. It can be achieved through onsite gain, so as part of the development that's being applied for, through offsite gain, either by the developer or by a third-party landowner through the purchase of units, or as a last resort through the purchase of statutory credits from central government through Natural England. There are various different nuances in terms of exemptions, how you deal with phase permissions, Section 73s, etc. But I think that's, in terms of a high-level overview, so how the system works in a minute.
Good stuff. And if anybody needs more a detailed overview, then our December 2023 edition is still available on YouTube, isn't it? Although I'm slightly nervous about encouraging people to watch both next to each other, because I haven't done that. I don't know how much of what I said would happen has been right or wrong.
It's something else.
But I think sort of in terms of looking at kind of, well, what have we learned? What's been the experience so far? We probably need to break it down, don't we? I think let's start with developers, i.e. those applying for planning permissions and needing to deliver statutory BNG. And I think it's probably fair to say we're going to focus on statutory BNG today rather than sort of any policy requirements out with that statutory condition. But what's been your experience so far in terms of how are developers finding the requirement for BNG and the process of overlaying BNG into a planning application?
I think the underlying point is that it's new for everyone, isn't it? So it's relatively new for developers, and it's relatively new for LPAs as well. So I think both developers and LPAs are in the process still of navigating through the requirements and how it works in practice when you come to applying for planning permission, when you come to discharge that condition. I suppose something that I think developers are really looking at now is thinking about BNG at an early stage. So well before application, I think really it's looking at BNG at the strategic level. So when you're looking at site selection, when you're looking at the design of the scheme, it's thinking about how does that fit with BNG. And that's linked to things like, if you're looking at the design of the scheme, can you achieve more on-site BNG to avoid having to pay third parties for units? It's things like looking at, if you're going to have to provide off-site BNG and buy units from a third party, can you locate your scheme near other sites where you can purchase biodiversity gain units from? And the reason for that is essentially the further away those third-party units are, the more you have to buy. So the metric works to devalue units the further they are away. But really, I think to summarise that, it's a case of thinking about BNG early.
I think the level of information you have to provide, I'd like to come on to later. But I think there's an interesting point for me that I'm seeing in terms of the extent, and perhaps I'm slightly surprised by how much developers are front-loading of their own accord the question of BNG in terms of that sort of thinking about delivering on site. And so I'm seeing more and more, particularly in areas where there's land available. So it's slightly different in urban areas where sites are more constrained. But when you've got development, whether it's data center, industrials, logistics, residential, whatever it is that's going in on greenfield sites, you're seeing actually a much larger red line for the application in order to take in the land next door, specifically with a view to it being identified on the plans up front as being BNG land. And I think that's been, as I say, slightly surprising to me, given it is a condition that ultimately you can worry about afterwards. It doesn't have to be there, but it's showing me that actually developers themselves, applicants for planning permission, they want to know up front, and that makes perfect sense. They can deliver it and what that looks like for their own purposes.
Yeah, exactly that. And I think that the thing there is it goes to viability, doesn't it? You can go and get a planning permission, but if then either you can't deliver the BNG or it becomes too expensive to purchase the third-party units, it's no good to you. And I mean, to your point around expanding the red line, we've seen that done to avoid the need to either purchase third-party units or to have your own off-site BNG registered. So the process for off-site BNG, so BNG outside the red line of the planning application, is you have to have either a Section 106 or a conservation covenant in place, and then you have to register that site with Natural England. So there's a process to be followed there and associated timelines. Obviously, if you can just expand your red line to include an adjacent site, it's on-site BNG, and it can be secured by conditional 106 as part of your own planning application. So it simplifies the process and avoids the need to involve Natural England in terms of registration. So I completely agree.
Yeah, absolutely. Although I suppose it has implications for the application fee, particularly where it's a significant chunk of land that's being included. But yeah, all of that needs to be thought about in the mix, doesn't it?
Yeah, it's balancing.
Yeah, and I think for me, one of the other things as an applicant that's been a challenge is actually how the metric works. And I can think of a few examples, again, sort of greenfield examples, and particularly where I've got a site in mind that I was dealing with where it was a big site, and there were a lot of drainage ditches running across the existing agricultural field network. And actually, it was really challenging because they were considered to be watercourses, notwithstanding the fact they seem to spend most of the year dry. But they were watercourses, and the requirement to re-provide the same habitat type. Actually, watercourses seem to be a particular issue because they're not easy to replace, and it gets very expensive very quickly if you're not careful.
Yeah, it does, and watercourses is an obvious one, but there are other less obvious habitat types as well that are harder to replace, and that's a question for ecologists. But there are other habitat types that we've come across as well, and what you see there is, I mean, watercourses I suppose you can provide in most places, but the issue with other habitat types is if it's a very specific type of habitat, it can only be suitable in some parts of the country, for example. So if you can't provide it on site, you're then looking at where can you purchase units for that habitat type, and it could end up being the other end of the country. At which point that issue which I mentioned earlier around the value of the units being reduced the further away they are from your site comes into play. So it can cause real issues.
Yeah, and with that one, there were also, as I say, they're basically drainage ditches. But when you added it up, there was miles of them because it was a big site, miles of them. But then suddenly re-providing that much of an equivalent habitat elsewhere became really, really quite expensive and had quite significant impacts on viability at that point.
Yeah, again, it comes back to viability. And I think that on that viability point, there's an interesting point that came out of the summer consultation that the government ran, so it was May to July. We haven't had the report from that yet, but one of the points they were consulting on was around viability and small sites, as they're called. So small sites were the sites that were captured in that April 2024 implementation that came after the main implementation. And sort of broadly speaking, those are sites of 1 to 9 residential units, or non-residential sites with less than 1,000 square meters of floor space. But with those sorts of sites, we often find it's very difficult for developers to provide, particularly if it's in an urban area, provide the gain on site, and then potentially looking to provide it off site becomes restrictive in terms of viability just due to the cost and the administrative burden when it's only a small site. So what the government were looking at in that consultation was, can they smooth the road essentially for these small sites? And one of the things they were looking at was relaxing those trading rules for small sites, amongst other things. But it's definitely on the mind of the government, I think.
Yeah, well, funnily enough, we've had a contribution come in while you were talking from someone who's saying that they're finding that the BNG requirement on small sites is creating viability issues and resulting in just those small sites not coming forward, which I think is echoing what you're saying.
And I mean, to build on that, the other things that the government are looking at in that consultation, they've also looked at whether they can relax the BMG hierarchy for small sites. So at the moment, the hierarchy, when you get down a few steps to the BMG elements of it, is essentially on-site, off-site, and then credits in that order of preference. And they're saying that potentially you could put on-site and off-site on a level step of the hierarchy, so that you avoid the viability issue with on-site gain. I don't think it necessarily addresses the economic viability issue in terms of off-site gain.
Yeah, and that, particularly in a housing context, those small sites, up to 9 units, they're quite often quite key to delivery of housing requirements and housing need. Windfall sites typically are those smaller sites, and they tend to be quite key to local authorities' housing delivery. So,
yeah,
the contributor is made is the government set itself this 1.5 million house target by the end of this parliament, which I'm not sure anybody believes they're going to hit. But no more credit to them for having a target that's stretching. But this doesn't help if BNG is acting as a block on those smaller sites coming forward.
Yeah, I know it's a topic close to your heart, Trevor, which is it's essentially which tool do you use to deliver the aim? So I think everyone can agree that the aim of delivering biodiversity net gain is a good aim. It's beneficial, but the question is, what's the tool that you deliver that with? at the moment, the planning system is that tool, which might be appropriate for some developments, and for others, it potentially then starts to impact on other aims like housing.
Yeah, very so. Just sort of moving on slightly, I think sort of looking at the landowner rather than the applicant for planning permission, when the landowner's got land that they're looking to sell to a developer, looking to promote development. I think there's overlap between them, I think, in terms of the experience, but it is slightly different. And the most obvious one is probably the other side of the coin to what we started talking about there, which is the developer looking to come and acquire your land is now looking to acquire a lot more of your land in order to deliver on-site BNG, although there's then a value issue around that in terms of quite what that does to land value, because that land is not being sold to deliver residential units on. I'm not a valuer. I'm not going to pretend I know how it happens for them, but there must be an impact, it seems to me.
Yeah.
In terms of your sort of price per acre, if you're also having to provide the land to deliver the BNG for the development. We're going to keep using the word viability, but it feels like that's there is a direct link between the BNG requirements and impacts on viability on that.
Yeah, absolutely. And I suppose that's the landowner element, where you're a landowner selling to a developer to deliver a site in terms of a development site. There's also the question of landowners who are looking to go and provide biodiversity units on their land to then sell to third-party developers, which I think one of the points which we were talking about a couple of years ago in the last outline was, is that this is a new market. Is there potential there for investors, funds looking at sort of ESG objectives to come in and look to sort of meet that need? And I think that's been done to some extent. There are more and more banks of biodiversity units in terms of landowners. We've also seen sort of intermediaries. So there are organisations you can go to who have a portfolio of sites which they can then look to assign to your developments. There certainly is a market developing, which was the original aim of the government in setting up this scheme, as opposed to a pure statutory credit scheme. I suppose, as we've touched on in terms of the points for developers, there is still a demand for offsite BNG, particularly for those rarer types of BNG. So if you're an investor or a landowner, and you're looking at which types of habitat you could provide, then potentially, if you're looking at those rarer types, they've got a greater value attached to them, and that might be pure chance in terms of your land is located in an area that's suitable, or it might be, if you're more of a strategic investor, you're looking at which land to invest in, and that would be a consideration at that point.
Yeah, and I think that there's a discussion to be had, isn't there, between the developer and the landowner, as to whether there is the opportunity, as part of providing BNG for a development, actually to provide more BNG that is needed in order to meet needs of others and to create some of that value. Question is, I suppose, who gets the benefit of that? Depending on the deal, the answer will vary. But that opportunity, and I've certainly seen developers who have an eye on, they know they need to provide it for their site, but actually they can see one of the ways of sort of offsetting the cost of that is to actually provide more than you need, and then yourself become a provider of
Yeah, exactly that. So you can see developers almost becoming landowners in terms of the roles that we've spoken about.
Yeah. And that sort of the landowner provider is a slightly different perspective, because we are seeing, and I know you particularly have acted for clients who aren't in the sort of the market for doing development on their land, but actually see the opportunity for creating value through selling the units and getting their land registered with Natural England. Yeah,
so essentially it's a pure BNG site. The only purpose it serves is to sell BNG units to developers, and there are lots of organisations doing that. I think an interesting point that we've come across acting for developers primarily is, as the developer, you know you want to purchase those units, but the question is, at what point do you pay the full purchase price for the units? So until the LPA signs off on the discharge of condition, you don't know that you're going to need those units. So as interesting sort of commercial arrangements between developers and landowners in terms of conditionality and sort of paying deposits rather than the entire sum up front, and how that then fits in with the planning process, which has been interesting to navigate with different LPAs and different approaches, because it isn't entirely clear how that system works from the regulations alone.
Yeah. So are you sort of seeing a trend in that? Are you seeing those with units to sell being willing to sort of go under contract, but with deferred consideration until the conditions discharged, or are they pushing to sort of get more upfront?
We've seen a mixture of approaches depending on the provider, and also whether we're dealing with a landowner direct or whether we're going through one of these intermediaries. So you find that the intermediaries will have a fairly standard form of contract, which they're looking to apply across all of their landowner sites. Whereas if it's a landowner by landowner basis, it's more open to negotiation, I suppose. But it's a point to think about on a case by case basis how that works with the development site and the timings.
Yeah. And just sort of a lot of what we've been talking about so far, in my mind at least, has been kind of greenfield development. I think it feels like BNG has been less of an issue in my experience. Now, watch comments come in telling me I'm wrong, but in my experience, it seems to have been less of an issue if you're dealing with brownfield land urban sites, where probably the value to start with in biodiversity terms was probably less. I'm not seeing as many challenges. I'm not seeing as much thought being given early in the process as to how you deal with BNG. I don't know whether that is echoed by your experience or indeed others who are
listening. It depends on the nature of the brownfield site, I think, in terms of what's on there. So if you've got a site that is genuinely zero value, then a 10% uplift is still zero. But even sort of scrubland or ex car parks that have become vegetated over time have a value which then requires an uplift. And I think that is a sticking point that's caused some contention. And I know that in the most recent summer consultation, one of the points that the government was looking at was, should brownfield sites be exempted? And I think it's for that reason, which is, while they may have, to the layperson, may have a low biodiversity value, there is actually biodiversity on the site, and it requires uplift under the current regime. So I think it can be a sticking point, although, as you say, if it's a zero value site, it's inevitable.
And I think the ones I've seen probably so far have been demolition and rebuild. So kind of they're not land
exactly.
to kind of go semi-wild again. I suppose when you are in an urban environment, when you do have that to meet, if you can't meet it on site, it becomes really quite complicated at that point, because the chances are you can't meet it nearby. You're going to have to look further afield.
Yeah. If you're in an urban environment, then I suppose the first issue is land comes at a premium, so delivering it on site is difficult anyway. And then, as you say, if you're then looking for a nearby provider of units, it's going to be difficult because it's an urban environment. And I mean, in terms of landowners and investors in land looking to provide third-party units, there's an element of strategy there in terms of where do you locate your land, where do you site these BNG gain sites, and if you've got an urban area, the answer would be as close as possible to maximise the attractiveness of them to the developer.
Yeah. And so moving on to planning authorities and sort of their experience of it, I think so. Probably the first one for me is almost always it's being delivered via 106 rather than conservation covenants. So I've not seen very many covenants. I know we've seen a few, but we haven't seen very many conservation covenants, which is the sort of specific mechanism that's set out in the legislation, isn't it, as the means of dealing with it. But there are some challenges, aren't there, for local authorities. If the offsite is or if it's on site, it can be dealt with in 106. If it's offsite but within your authority area, it can still be dealt with through the 106. You still have enforcement powers there. But it is, I suppose, firstly, it's more tricky if we look at the area, the situation where you're going outside of the local authority boundary. a planning authority is only enforcing authority for 106 that's within its administrative area. So we've seen a few examples of challenges there where the mitigation, the replacement is being provided across local authority lines, haven't we?
Yeah, we have, and when you go and look at, there's a list that's published on the Natural England website of the responsible bodies. I think there were 33 of them in August of this year, and there's a real mix of bodies on there. So to rewind, responsible bodies are the body that can enforce the terms of conservation covenant, which is the alternative to a 106 for offsite gain. And as I said, there's a real mix of bodies on there. So you have wildlife trusts, you have charities, you have, as you said, LPAs, so they can look to enter into conservation covenants outside of their administrative area. And you also have some private companies as well who are clearly looking to provide a service through this mechanism. So I think, I'd agree with you that the typical approach seems to be the use of a 106 in the standard cases. And I suppose that makes sense because it's what LPAs are used to, it's what developers are used to. But the conservation covenant does have a role where you've got a more unusual scenario. And in some ways, I suppose it could be attractive in that if you can reach an agreement with, say, a local wildlife trust, it avoids the interaction with the LPA as well as the landowner in respect of an offsite gain. Obviously, the LPA is still involved at the discharge of condition stage, but in terms of registering the site, it can be dealt with in a silo, essentially.
And I have seen some nervousness from planning authorities around that, because planning authorities, they are always worried about ensuring they have control. And that partly, I think, is just a nervousness about not having control, but also actually they need to be able to place weight in their planning decisions. They need to be able to place weight on things, and one of the ways that they can place weight on it is if they know they have control. It can be harder to place weight on something if they're not in control. And so I have seen a little bit of nervousness when an applicant for planning permission is looking to enter into a conservation covenant or has already entered into the conservation covenant with an alternative provider, because the LPA can't insist on being the enforcing authority. It's almost a buyer's market at that point. You as applicant get to choose who your enforcing authority is. And I have seen sort of local authorities get a little bit nervous about that. And I've seen it also actually within the authority administrative area. And that particular local authority really didn't like that. The mitigation, the offsite provision was happening within their area, but they were being cut out of the enforcement process. So I think it's just something, it's there, it's on the statute book. I don't think a local authority can reasonably refuse to take account of the offsite just because they're not the enforcing body under the conservation covenant. But there is a bit of a tension there, I think.
Yeah, there is, and the reason for that is essentially because it's pre-commencement discharge of condition is the last point at which the LPA would be involved in that scenario. So once they've seen the conservation covenant and the offsite gain has been secured, the pre-commencement condition would be discharged, and then after that point, if they're not a party to the conservation covenant, it's then for the responsible body to enforce that rather than the LPA. So you can see the nervousness, but as you say, it's set out in the statute. It's one of the options that can be followed, and it's a viable option.
Yeah, we're getting quite a few questions. We'll pick up most of them at the end, but one that's come in that's sort of on the point we're discussing, so I'll bring it in now, is when you've got an on-site provision. And the question says, if it's not appropriate to use 106, can you use conditions to secure it? And sort of, I can't quite think when it wouldn't be appropriate to use 106, but I think I haven't seen it done by condition. And I think for me, there's some difficulties with conditions, given that you need to have secured it for the minimum 30-year period. But have you seen conditions used for on-site rather than a 106 obligation?
I've seen draft conditions. I haven't seen them on a permission that's been granted. So the legislation says that if it's on site, it can be conditions or 106. So it's a route that's open to be used. I suppose the point to think about with conditions is you have to have those conditions at the point that the permission is granted. So if you're looking to use permissions for on-site gain as an applicant, you're going to have to be very clear with the LPA as part of your application what the proposals are, so that they can then go away and draft the conditions and impose them on the planning permission. If you're looking at a 106 for on-site gain, potentially the 106 can come later at discharge of condition stage. So I suppose conditions would front load the process in that sense, which isn't necessarily a bad thing, but it's a point to consider.
You're absolutely right to point out it's in the legislation that conditions can work. It's interesting to me though how it works in practice, because you've got to secure it for 30 years. Well, I can make an application for a Section 73 at any point. I suppose at that point it would just have to be refused, but it feels like there's a sort of an issue there around quite how you secure it into the longer term.
Yeah, the way I've seen it in draft conditions is through a habitat maintenance and management plan. So it'll be a condition that says you have to submit the HMMP and then comply with it, and the HMMP will say it's a 30-year term. So it's sort of through that mechanism that it would be secured. But as you say, Section 73 is an option, although it would probably be refused.
Yeah. So somebody else has just sort of come in and said they've seen conditions securing on-site gains as well. So it's clearly it must just be me that hasn't seen them yet. They're clearly out there and being used. But the person that's made that point has also sort of flagged, and it is an interesting point, the statutory condition that delivers the 10% requirement in the first place. The contributor's making the point that government guidance recommends that condition isn't actually attached to the permission, so it isn't set out as one of the conditions. And the question, the point that's being made is that seems to increase the risk of it being missed and forgotten about later on in the process. I haven't seen that yet. I haven't seen local authorities forget, but you can see, particularly as an applicant, if you're not an experienced developer, you wouldn't necessarily know, particularly on those smaller sites. You know, if you're an individual that's got a planning permission for your own house or whatever, you're not necessarily going to know that you've got a condition to comply with if it's not on it. So I think it's a good point, but I haven't seen it. We don't tend to deal with smaller sites, which feels like where it may be more likely to be missed, but I haven't seen it be missed yet. I'm not sure whether you have, Henry.
No, I suppose two points on that. That's right, that you wouldn't see the deemed condition on the face of the planning permission, and the guidance says that the LPA shouldn't put it on there. There is guidance saying the LPA should put a note or an informative on the decision notice that essentially explains that BNG applies, and explains whether they consider the permission to be a phased permission or not, because the requirements are slightly different. And there's also a point around validation as well. So when you submit a planning application, there's the list of minimum information requirements, and those have been updated to account for BNG. So one of the things that an applicant has to put on their application is a statement as to whether or not they think BNG applies. So the applicant, in order to make a valid application, is, I think, forced to at least think about BNG. But yeah, completely right. The condition won't be on the face of the decision notice.
Yeah, which is an oddity.
It's unusual. Yeah.
The only sort of the nearest equivalent is the statutory condition on time limits for implementation, which in theory a local planning authority doesn't need to put a condition saying you've got to in 3 years. If you don't put it on there, the statutory condition applies. But yeah, I can't remember seeing a planning permission where a planning authority, even where they're using the statutory basis, doesn't repeat that condition. So it is a sort of unusual one. I'd be fascinated to know what the logic was of not requiring it to be put on the face of the permission, but there you are. But whether it's there or not, ultimately it's a condition that can be enforced in the usual way. If BNG is missed, planning authorities have powers to enforce against it as they would any other condition.
Yeah, and the same point applies for 106 as well. If you've got BNG requirements in your 106, it's the same route to enforcement as for any other 106 obligation. And
it's a pre-commencement condition.
Correct, yeah.
So if you don't do it within the time limit, then your permission lapses. So don't forget, would be a key point there, wouldn't it?
Takeaway point from today's session.
I think and this sort of comes from very personal experience with an appeal I was dealing with earlier this year. I think one of the challenges is that I see is local authorities wanting a lot of information up front and effectively almost wanting the biodiversity net gain plan to be available at the determination stage, which of course the condition doesn't require. This is not a front-loaded process under the 1990 Act. And I certainly saw that on an appeal earlier this year when the planning authority were saying that one of the reasons, at one point they were suggesting it was a reason for refusal, was that we hadn't proved that we could deliver biodiversity net gain, which seemed a slightly odd process because could you always prove it? Because as long as you're prepared to spend enough money on it, you can ultimately buy statutory credits if you can't do it any other way. So there's always a way of doing it, whether it's viable or not. But the issue never actually got determined in the appeal because the planning authority chucked in the towel about 24 hours before the inquiry opened. So had one of those weird inquiries where we were fighting no one, and we won. Surprise, surprise. But it was a very live issue until they threw in the towel on the more substantive issues. I don't know if you've seen similar situations where planning authorities are perhaps wanting more information than they should up front. And that can be complicated if you haven't fully resolved and haven't necessarily done all of the surveying to know exactly how much habitat needs replacing, potentially. What's your experience?
I mean, so I suppose the start point is what's the statutory requirement to submit a valid planning application, and there's the minimum information requirement, which, as I said, it's relatively low. It's essentially what's the existing value of the site and does BNG apply or not. There's then potentially an added level of any local requirements for that particular local planning authority. So they've got their list of local information, which may have more information on, but the baseline requirement from the statute is low in terms of BNG information. There's nothing to stop a developer getting ahead of the game and looking to have those conversations early. There's nothing to stop developers submitting a biodiversity gain plan as part of their application. Again, if they want to de-risk the process and make it less likely they get a refusal of discharge or condition at a later stage. But in terms of an LPA being able to refuse a permission because they're not content with the BNG permission, I think the scope is very limited. The PPG for BNG, it's paragraph 19, has got a line in it which essentially says generally it would be inappropriate for LPAs to refuse a planning application on the grounds that the BNG objective won't be met. And the reason for that is the whole way that this system has been structured is so that BNG is a post-consent matter. It's a discharge condition. So if you're a developer, you can go through, you can get your permission and not have to talk too much about BNG until post-grant permission. And as you say, if you get to that point post-grant permission and it's really difficult to provide BNG on site or off-site on your own land, ultimately you just go and pay for units on a third-party site or, as a last resort, statutory credits. So I think it's very difficult to see where it would be a ground for refusal.
I think that's the key point for me. There are lots of reasons why an applicant for planning permission may want to have nailed it down to some extent, at least up front, but it is ultimately the applicant's choice. I think that's the point. Authorities can't insist on it. It is not a reason for refusal. I think the PPG is helpful in that. You're quite right. But yeah, the appeal was a particular example because it was an appeal. But I have seen the problem is if you're not in an appeal, if you don't want to go to appeal, and a local authority is wanting it up front, you're on that over a barrel situation again as an applicant. But you know, the legal position certainly is that they can't require it and use it as a reason for refusal if that information is not forthcoming, and if a developer does want to take the risk and worry about it later on.
Yeah, completely agree.
That probably segues us in. I'm conscious of time. That segues us in to the look ahead and the NSIP process, because it's backloaded, as we've just said, in the 1990 Act. But one of the differences in terms of how it's proposed to work with NSIPs is a much more front-loaded process. Although there's an ongoing debate as to whether we're ever actually going to see BNG come in on NSIPs. So where are we at the moment, Henry, with DCO regime and nationally significant infrastructure projects?
So I think this is potentially an entire session in its own right, but the latest position on NSIPs was set out in the summer consultation, which was May to July, and that pushed back the proposed implementation date to May 2026. It was originally November of this year. So it's obviously it's been delayed for a reason, and I think it's really difficult to get right. So in that consultation, some of the proposals that stuck out to me were, as you said, one of them is front loading the process, which is typical of the NSIP regime anyway. But for NSIPs, rather than it being a post consent matter to get the biodiversity gain plan approved, it would be part of the application that we dealt with through examination. Another sort of difference, I suppose, with the proposals for NSIPs as it stands is the idea that they'd be putting on-site gain and off-site gain on a level playing field. So in the same way that we spoke about for small sites, so that in terms of the hierarchy, providing on-site gain or off-site would be treated as the same level of preference. And I suppose part of the reason for that really is around where you have a long linear scheme and you're looking to provide BNG, potentially you'd be looking to acquire land purely for BNG purposes, which could be problematic. Having those two routes on a level playing field gives you the opportunity at least to go and look at off-site options rather than having to exhaust all the on-site options first. I think it's interesting, obviously the statutory regime hasn't come in yet for NSIPs, but there have been some decisions in the last sort of year or so where organisations have looked to provide BNG on a voluntary basis or to meet policy requirements, and that's been treated favourably by inspectors and the Secretary of State. I think most recently there was a DCO for a transmission project where the inclusion of compulsory acquisition powers for land purely in respect of voluntary BNG was approved. So it's clearly something that's coming through the system on a voluntary basis. But I think there are some real challenges if it were to come in May as programmed.
Yeah. And is it going to come in? Because it sort of feels as if the sort of the political momentum has shifted, and it's being seen, infrastructure is being prioritized, infrastructure is seen as a way of delivering economic growth, but equally a lot of infrastructure is publicly funded and there's not a lot of money to do it, and BNG just pushes up the cost of some of that infrastructure. And I sense the sort of, perhaps the government doesn't want to be seen to be backing off from BNG, but also the Treasury particularly perhaps is not enamored with pushing up the cost of infrastructure. it's an impossible question to answer at this stage, but I just kind of sense that I wonder whether it will get kicked into the long grass, assuming that's not particularly biodiverse and valuable grass.
I think there's nothing in the consultation to suggest that, as you'd expect. I think it does though come back to that point earlier in terms of which tool do you use to deliver the aim. So if we agree biodiversity net gain is a good aim to have, but is nationally significant infrastructure the way to deliver it if that has its own aims that have to be delivered, as you say, economic growth? It's impossible to say, isn't it? But I can see why the government would look to backtrack. And I mean, ways in which they could do that, thinking about, again, linear projects. As it stands, the regime would apply to the overall draft order limits of that project. So if you've got sort of temporary possession, or you've got easement widths where no physical development's taking place, the BNG requirement would still be based on that land. So in terms of easy ways to soften the requirement, exemptions around things like that could be an option to backtrack without fully backtracking.
Yeah. You keep trying to tempt me into my rant about how the planning system is used to solve all of society's problems, and it shouldn't be, and that's part of the reason that delivery is so dire. I'm desperately resisting. I've done it for 46 minutes now. I'm determined to keep resisting going into that rant. I can see you push me towards it, but put aside the same arguments potentially apply to all development, but particularly with infrastructure, that is, it's about a national need, a public need for infrastructure. This isn't sort of private development creating private value. Even privately funded infrastructure projects, nuclear power stations, whatever, they're about meeting urgent, pressing needs. That net carbon, zero carbon agenda, economic growth, all of those things are themselves important aims, and so there is that tension, I think, when you try to then use those projects to deliver other urgent needs. There's kind of I can see that real tension there that I think is particularly difficult in the context of infrastructure.
Yeah, and the government, so on the consultation, that a holding response was issued on the 21st of October, so 2 days ago, essentially saying we're still thinking about it. So it's clearly a knotty issue.
Yeah, I suspect there's a conversation going on between DEFRA and the Treasury and others, I suspect, as to quite what the priority is and what the taxpayer can afford. And whether the impact on infrastructure delivery is justified or not. Glad that's not on my desk, although I think it's clear where I'd go with that, given your constant hinting of my frustration with that particular topic. But it will be a very much, if it does come in, it will be a much more front-loaded process, won't it? And I think that's sort of an interesting point. Presumably, therefore, given infrastructure projects are a long time in the making before they get to application stage. If it does come in, I presume there will be quite a long lead-in time, because otherwise you're unlucky if you're a month away from submitting your DCO application and suddenly you get caught by a statutory condition, because that potentially is a massive rethink of the amount of land take you need within your CPO powers or whatever, if you've got to deliver what could be huge amounts of BNG for I'm thinking particularly of sort of long linear projects that are cutting through various different habitats and things. That I guess if it does come in, there's a recognition that infrastructure providers are going to need quite a lot of time to incorporate that into projects.
Yeah, there has to be some element of lead in. I think what I would say is the requirement's obviously been aired for a couple of years now. So I think the clients we're working with on infrastructure projects have been thinking about this for some time. And in terms of new projects that are in the pre-application phases, it's on their minds. So strategy is already being put in place, and these things are being thought about. But even so, as you say, if it comes in with a very short lead in, it's going to cause problems.
Yeah. I am conscious of time, as you say. NSIPs is always a topic in its own right on these things, although at the moment it's a bit sort of who knows. So it's probably one we come back to once we have a clear idea of where the government's going.
Absolutely.
If we move on to some of the questions, because we have had a lot, so I'll try and cover as many as possible. One question that's come in, Henry, is what the position is with BNG in Scotland.
Yeah, there's no statutory requirement in Scotland for BNG. There are proposals for it. I know it's being consulted on. Our colleagues north of the border have been involved in the consultation. But yeah, as it stands, no statutory requirement. There may be policy requirements at a local level.
And the next question has come in from a planning consultant. It's a site-specific one. As it happens, I'm meeting this planning consultant later this afternoon for a meeting on a different site. So I shall send her the bill at that point. But the question is, there's a client which happens to be a university, but obviously with a large landowning and a campus. They can't meet the BNG 10% requirement within the red line of the application they've put in, and are wanting to provide it off-site, but within their own campus. So the question is, in that circumstance, would the off-site land need to be registered with Natural England, given that they're not paying a third party, or could you just include it within the 106, given that you are the landowner anyway and can sign up to deliver the BNG there?
Yeah, so the test, if you like, for on-site versus off-site is it within the red line for the planning application? So the two options really would be, can you expand your red line to include the BNG element? And if not, then you would need to go through the process of registering that other site with Natural England so that it counted as offsite BNG.
Yeah, it feels like an odd. That I agree with you. That's the answer, but it feels like an odd answer because it's sort of slightly daft. But the obvious way to avoid it is to include that offsite within the red line, and I think your red line doesn't, to my mind, have to include everything between the two. You could have a red line that has a gap potentially if you needed to. If that's more attractive than having to go through the trouble of registering the mitigation land with Natural England. We haven't really talked about that process though. Have you any experience? I don't. But have you experience of registering land with Natural England? Is it a straightforward process, or is it something that's to be avoided if you can?
I've not been through the process. I've spoken to people who have, and I think there were potentially teething issues early on. There are statutory time frames for it, but I think there were some delays early on. As I understand it, it's speeding up, but haven't been through the process.
Now I've got a question here about OMH. I have to say I don't know what OMH is. So Henry, do you know what OMH is? If not, the question, we can't answer it. So there's no point asking it. So do you know what OMH is?
No, I don't.
No. So if the questioner could quickly, there we are. I've got the question has come back. Open mosaic habitat. Have we dealt with any sites that have open mosaic habitat where we've had to offset or mitigate that via habitat?
Yeah, I haven't, as is probably evident from my blank look when you said OMH.
Yeah, well, we're both in the same boat on that one. So apologies. It's not often we get a question that we can't answer, but that one, well, I suppose we can answer it. No, we have not dealt with any sites that have OMH that's needed to be replaced. Another one is if the land is probably similar to, and I think the answer is probably therefore the same in terms of the university example we were just given. But if you've got land adjacent to the site that's within your ownership and it's included within the blue line on the plan, can you link it with a condition? I mean, it seems to me you can impose a condition. People often forget this, but you can impose a condition that applies outside of the red line, but within the blue line, i.e. land within the control and the ownership of the applicant. You can have a condition. So I think that is an acceptable route, but you would, I think, still have needed to have registered that offsite land with Natural England in order to make that work for the same reason you've just expressed with the 106 approach, wouldn't you?
I think it would have to be 106 for BNG at least. So you can obviously have a condition for offsite works for a standard condition. For BNG, the only instance you can use a condition is if it's on site, which is essentially within the red line for the planning application. So if it's adjacent but within the blue line, it would have to be a 106 or conservation covenant and then registered with Natural England, or you could expand your red line if it is adjacent. So it's a slightly different set of rules.
That's new to me. So the statute excludes the use of conditions for land outside of the application red line.
Yeah, so once it's outside the red line, it's off-site BNG, at which point it's, as I said, conservation covenant or 106 and registered with Natural England.
Every day is a day, and that is why I never advise on BNG without talking to you first, Henry.
The question there, it says adjacent, doesn't it? So if it's blue line adjacent to the red line, the easy fix to me, obviously depends on the site, would be to expand the red line.
Great. And then one last one has just come in, which we've probably got time for, which says we've been using separate blobs of red line under one application to meet the requirement, but keep the square meterage low. This is sometimes accepted by planning authorities, but we've never been sure on the legality of this. Any advice? I think that's what I said earlier. I don't see there's a difficulty with having your red line doesn't have to be just a single red line. I think you can have it split if needs be. So I think legally, I don't see there's a bar to that as a basic matter of planning law.
Mm-hmm.
So you keep using the blobs to keep that application fee down. Great. Well, that we always ensure we do finish within the hour, and we've got a minute or two left, so that feels like a really good point at which to draw this to a close. Henry, thank you very much. As always, pleasure to have you, and particularly have your experience in this field, one that we will no doubt return to when we get more clarity on NSIPs and the DCO regime in particular. But thank you in the meantime. As ever, thank you to you, the audience. This will be available on YouTube, on our YouTube channel in the next few days. So if you've enjoyed it so much you want to hear it again, then please do feel free. Otherwise, Outline will be back next month when we will be having the CPO session that we had to cancel last month. So we'll be back talking about CPO next month, although I won't be back because I am in the Lands Tribunal for much of next month. So my colleague Sophie Stewart will be in the chair, and I hope to see you again very soon. But thank you to everyone, and goodbye.